Good morning, everybody. Welcome to my live. Brian Lerner, immigration attorney, 30 years of experience, give or take. And so, for this particular live, I'd like to talk about the EB1 Extraordinary Alien Petition, but I'd like to focus on the term extraordinary, what it means. So what I'm going to do is discuss that a bit, get into some specifics, go into some details, and then after, I'll go back and I'll answer your questions. So as long as it has to do with immigration, I don't care what area of immigration, adjustment, deportation, removal, waivers, consulate processing, non-immigrant visas, work permits, citizenship, naturalization, derivation, whatever. You go ahead and ask it, and I will scroll back to the beginning once I'm done with my introduction, and I'll answer your questions at that time. Okay? So, first of all, what is EB1? Okay, now I've done lots of intro videos and lots of videos on what exactly EB1 is, but first keep in mind just the initials themselves. EB means employment-based. 1 means first preference. So employment-based first preference petition. It's the creme of the crop, okay? It's the top. It's where anyone would want to be if they could, okay? There is no visa waiting. There's no priority dates. It's as far as now. Watch after today it'll be different. But as of now, priority dates are current on EB1 all over the planet, and you don't need to have a petitioner. Okay, it's a self-petition. Okay, which means, I get a lot of queries from all over this planet saying, "Can you help me find a petitioner?" And of course, I have to tell them, I'm not an employment agency. I'm an immigration attorney. Okay, I don't look for people, for petitioners to petition people. Okay. On a side note, I once knew a very prominent immigration attorney, and he did exactly that. Okay, it was he and some others, and what they were doing were H-1B visas, and they were making up the petitioner. And they got indicted, federally indicted, and they got visas, and they were making up the petitioner. And they got indicted, federally indicted, and the guy got behind prison. Of course, he got disbarred, and he got behind prison. Okay? So I'm not saying that if I help somebody find an employer to petition them, it's illegal. But number one, there's certainly a conflict of interest. I would be representing the employer and the employee. That's how an employment petition works. So if you need to find an employer, of course, you need to find an employer, and then I can, be retained to prepare the petition. So I know, of course, it's difficult to get an employer to petition you, especially when you have to go up to them and say, by the way, I need you to petition me and go through the whole immigration process. And believe me, I know how fun that is. That'll dissuade 95% of anyone from petitioning you. That's the reality. So if somebody can be petitioned by themselves, if they can self-petition, then they would take advantage of it, right? So the United States government loves EB1 applicants because they're at the top of their fields. They bring in prestige, money, business, all kinds of stuff. And so they want EB1 applicants, which is one reason why there's no backlog. But of course, another reason is that it's so hard to get that, for every 100 that apply, I don't know what the statistic is, but there's not that many that would get approved. So when it says extraordinary, I have to put this out because I get so many queries like the following. I'll get someone who's getting their PhD. they won't even think twice that they don't qualify. They'll think, because they're getting their PhD, that it's a shoo-in. It's a easy peasy deal to get the EB1. You know, they think something to the effect, I'm getting a PhD, who else is doing that? And therefore, I must be extraordinary alien material and myself for an EB1. And then I go through the same spiel all the time with them. I go, what exactly makes you think, other than the fact you're getting a PhD, that you think that, that you believe you're EB1 caliber? They'll go, well, I've read all the requirements that are needed, where, you either need a Nobel Prize or 3 of the following. And go, I have 3 of the following. I published 2 papers. I'm an intern and I get a lot of money, or something. And then they'll list one other thing. And then they'll just say, okay, it's in. I'm in. So I have to explain to them. I should really write a generic response, because it happens a lot. I have to explain to them first, extraordinary does not mean when you get your PhD, you're extraordinary. I mean, obviously it's not easy to get a PhD. Obviously, you've worked many years to get to where you are, and obviously it's not easy. But that's a different cup of tea than being extraordinary. I've gotten extraordinary alien petitions approved for people who didn't even go to college, believe it or not. I did one about 20 years ago. As a golf coach, believe it or not. I got an EB-1a approved for a golf coach, okay? So what the EB-1a is, what extraordinary means, is that you are at the top of your field, whatever it happens to be. Okay, I mean, there's obviously more defined legal definitions of it, but that's the gist of it. So you have to ask yourself, is getting a PhD make you the top of your field? And the answer is no. Flat out no. Okay? Just pick a subject. PhD in computer engineering, PhD in microbiology, PhD in agriculture. None of it makes you at the top of your field. Okay? And I can tell you that there's another similarity, that when these people, contact me, these PhD students contact me, and they think without doubt that they qualify. I say, well, what work experience do you have? And they'll say, well, I've done like 3 years of internship while going to school. I mean, think about it. Who's going to consider someone the top of their field where the only work experience they have is an internship? I am for sure not putting down an internship. I think they're fantastic. I think they're needed. I think they're great. But that doesn't put you at the top of the field. Okay? So, extraordinary, you first have to get out of your mind. And when I say you, I'm talking about the people who, the PhD students who think that they qualify without doubt. They have to get out of their minds that just because they're getting a PhD that they qualify. It just doesn't follow. And sometimes I try to explain it to them and they just don't believe me. And they go and try to submit it on their own. And then a year later I get a thing saying, I don't understand. Why didn't I get it? So I have to go back and say, well, I say tactfully and legally, but I basically say, I told you so. Okay. There's all kinds of ways a PhD candidate can qualify for an employment petition than an EB-1a. So another thing that extraordinary means, or I should say doesn't mean, is if you look at the list of what they say is required, and if you happen to fall under 3 of them, that also does not mean, boom, you're in. No problem. Okay? That is the starting point. I'm not kidding you. When I do an EB1 petition for a client, it's like about that thick. And that's not garbage thick. That is pure work relevant thick. Okay? Meaning at every page of it, every argument, everything in there goes to why and how that person is EB1. I can tell you that what green lawyers, that's what new attorneys do, is they fill a bunch of junk in a petition. They put a bunch of irrelevant stuff in there. And they think because it's bigger, because it's thicker, that it's better. And likewise, that's not the case. Okay? It all has to be relevant. I've done petitions that are thin, but it comes and has exactly what it needs. Okay? So anyways, the idea here is that when you're doing EB5, sorry, I have my mind on EB5. There is an EB5. We'll do something else on that. But when you're doing the extraordinary, first, understand when it goes to immigration, it is difficult. It is an uphill battle. It is a discretionary decision. And you can't buy the person to grant it. The person doesn't get 1 penny more whether they grant or deny it. I mean, that's the reality. Okay? You can be an adjudications officer and make the exact same amount of money whether you grant or deny an EB1. All right? What you do have to show as an adjudication officer is if you grant it, why you granted it, and if you deny it, why you denied it. So it all has to be documented. Okay? So that's the bottom line there. So once you get out of your mind that you are for sure EB1 category, okay, then that's a good starting point. Okay? Why should we waste half our time telling you why you're not EB1 category when if you come in the door with an open mind, or as they say, have your cup of tea half full, then I can explain to you what's needed. I can let you know what's required. And most of all, I can let you know it's not guaranteed. Okay? Now, I'll do an EB1 if I think there's a reasonable chance of success. I won't do one if I think there's not a reasonable chance. So just if I were to do percentage-wise, the number of doctoral students or people who even got their PhDs but don't yet have an employer to petition them, but they just got their PhD and they have their nice certificate, of 100 that contact me thinking that they're EB1 caliber, luckily, I'd be lucky if 10 of them really qualified, okay? Which means 9 out of 10 of those doctoral candidates or doctoral students are not EB1 category, are not EB1 caliber. They're good, they're really smart, they've worked really hard, but they're not EB1 caliber, okay? There's a reason immigration makes it so hard. And there's a reason it's called EB1, okay, not EB2, 3, 4, or whatever, okay, because there are categories full of that. EB5 happens to be the lowest number, except that's a very hard one too. That's, investing $1 million or so, minus that. So that is basically my spiel on what extraordinary means and to give a realistic effect. Now, I don't want this to dissuade people who might be qualified from contacting my office to see, okay? Like I said, there's people who don't have advanced degrees that get the EB1, okay? So that by itself is not a qualification. I mean, it's nice to have it, but it's certainly not a qualification for it, okay? So my process is first I will analyze their whole situation. And it doesn't take long, okay? I basically need to see their curriculum vitae or their resume, work experience and all that. I mean, basically anyone who's going to try to get an EB1, they have a curriculum vitae. And then I can see if there's a realistic chance. Honestly, it takes me about a minute to make a decent analysis based on my experience, whether they do or don't. And I will not take it if I don't think they have a chance. I mean, some doctoral student comes in and goes, I am EB1 and I want you to do this no matter what because I know I qualify. I did 15 minutes of research on the internet and I know I qualify. Okay, so those type of clients, I say, well, it's been nice knowing you. Goodbye. Go find a lawyer who will do it before it gets denied. So I obviously don't take stuff where it's guaranteed to be a success. Otherwise, if it was so easy, they wouldn't really need a lawyer. I only take ones that I think there's a reasonable chance, and then I make the best argument possible. And it takes a while. Okay, I mean, someone's not going to come in with an EB1 and you're going to have all the evidence and arguments and everything else for showing extraordinary ability created in a day or a week. Okay, I mean, a lot of times it takes a few months to create a good EB1 petition, realistically. Okay, so that's that. Let's go see if we have any questions here. Let me scroll back. This is where I say, hello, everybody. Welcome to Monday. I hope that everybody is having or will have a good week. It's real foggy out where I am. Okay, let's see. I'm just scrolling down now. We have lots of people that joined, but so far I don't see questions. Give me a second. Okay, I'm just give me a minute. It takes me a minute to scroll to get to where the questions might be. 1 second. We're almost there. Okay. Patience. As they would say in Star Wars, patience, Padawan. Okay. Here's one. Do you know how long the I-61, I don't think you spelled that right, but waiver takes to get approved? So it's a little unclear which type of waiver you're referring to because there technically is no I-61 waiver. But I have a couple things to say about this. First, by you saying how long does it take to get approved, it is sort of indicating that you believe that there's no chance it won't get approved. Okay? So the real question is not how long does it take to get approved, but how long does it take to adjudicate, to rule on. Okay, that's the real question. You never, ever submit anything to immigration thinking automatically it's going to be approved, especially a waiver. I mean, think about what a waiver means. You are inadmissible for some reason. You know, either committed fraud, you have a crime, you're unlawfully present, you don't meet the public charge requirements, you have an infectious medical disease. Okay, I mean, there's all kinds of reasons. You know, you have a prior deportation order, whatever. So there's all kinds of reasons someone is inadmissible. So the law says right off the bat, if you're inadmissible, you can't come in. You can't get the green card. So a waiver is basically immigration saying, okay, we know you're inadmissible, but we're going to give you a chance to forget about that inadmissibility and allow you to show us why we should say, okay, forget about it. We're going to let you in. We're going to waive that ground of inadmissibility. Now, that's not easy to do, okay, which is why you can't assume it's going to be approved. You have to convince them. With immigration law, pretty much you have to assume the moment that you file something, they're going to start off wanting to deny it. That's a fact. Okay, that is an honest fact. And your petition, your waiver, your application has to convince them otherwise. You know, has to. Let's just say you're waiving because of a crime. Well, by the end of when they're done reading the waiver, you want them to say, oh, okay, I understand. I know that this guy committed a crime, but I see that you know, he's got U.S. citizen relatives, that he's got lots of ties in the U.S., that he's done rehabilitation, that there was a reason that he committed a crime, that he was young and stupid and things like this, that he's turned his life around, that he volunteers, that he has good moral character now. You know, he's got 4 kids. You know, I'm just saying that there's lots of reasons, and that maybe there's a psychological report that shows, you know, maybe some bad stuff was going on in your life at that time, and that's why you did it, or it was related, or maybe it was related to abuse, whatever it is. You know, I could go on and on. So there's the waiver itself has to be prepared very carefully as well. You understand the door to get into immigration is to get that waiver approved. So the waiver is more important in actuality than the petition itself. You might have a fantastic underlying petition, but unless the waiver is approved, it doesn't matter. So given I said all that, it depends what kind of waiver you have, okay? Sometimes they take 6 months, sometimes they take a year. If you think, if you're going to apply for a non-immigrant waiver, if you think you're going to apply for a non-immigrant visa and a non-immigrant waiver and walk out the door with both of them approved, that's never going to happen. Okay, it always takes time. Okay, you're at their disposal. So that's that. Okay. Well, somebody said hi to me, so I guess I can say hello back. Okay, let's see. My account with the nitration, it says it will take 3 months to receive the note and respond back. Well, I assume that that's a misspelling. I assume nitration is immigration, because I have no clue why you would be talking to someone about nitration. But you can't take that as the holy gospel, okay? If they say that it's going to take 3 months, and in 3 months and 1 day, you're on the phone demanding an answer because they said it would take 3 months, well, you're going to get nowhere with that. There's a reasonable period. Okay, if they say it's going to take 3 months, which honestly is going to take more than that, it will take more than that, then that's the average, perhaps. Okay, it depends where you are, it depends on the adjudication officer, it depends on the issues, it depends on they're going to issue an RFE, a request for evidence. Again, your focus should not be so much on how long exactly it's going to take and when is the approval coming in. That is presupposing it will be, okay? Your focus should be, especially if you did this yourself, you need to get it to an immigration attorney who knows what they're doing to supplement it before a decision comes in, to make it a lot stronger, okay? I can tell you it's a lot stronger, it's a lot easier to supplement something before a decision comes than to appeal the denial and try to get it reversed, okay? That's a fact, okay? If someone has 2 negative and is getting deported, is there a way they can stay in the U.S.? You forgot to say negative what? Okay. I'm assuming that you're saying, maybe 2 crimes, maybe, perhaps you're saying 2 unlawful entries. It depends. I'm going to need more specifics as to what exactly you're referring to. Okay, 2 negative what? Now, if they are getting deported, I'm assuming they're in removal proceedings right now. And then the question becomes whether there's any relief. Now, the reason that people can't just get thrown out of the country, I mean, there are ways they can if they try to make an entry at the port of, enter at the port of entry and they're inadmissible for some reason and they're expeditedly removed. Okay, that's basically being thrown right out. But if you're inside the U.S. and you're in deportation or what's called removal proceedings, then there is certainly ways of fighting it, okay? There's all kinds of ways of fighting it. Cancellation of removal for lawful permanent residents, cancellation of removal for non-permanent residents, withholding of removal, Convention Against Torture, asylum, adjustment of status with a waiver. I could go on. There's all kinds of ways. And it depends. So I'd need to know if they're an aggravated felon or not. I'd need to know on the grounds that they're being deported. I'd need to know if they were previously deported. Each case is different. Bottom line answer is someone in deportation has the ability to win and stay here. Otherwise, there would not be any need for immigration judges. Okay, people would just be deported. That's that. Okay, that's why, to be honest, when you hear a presidential candidate say that there will be mass deportations, the biggest ever in history, that's not going to happen. That's not going to happen. You can't do that. There's due process rights. Okay, if somebody is here in the U.S., even if they're not a citizen, even if they're not a lawful permanent resident, they have legal due process rights to fight their case. And it's in the law. Just because they don't have U.S. citizen attached to their name does not mean they can be thrown out of the country. That's a fact. Okay. Okay. Let's see. Just a minute. Sometimes I scroll down and it goes down like 100 and then I have to scroll back up again. After an interview, why wait 120 days? My husband was approved. He did not get an interview. Okay, well, first of all, I assume you're talking about adjustment of status. Okay, you're probably a U.S. citizen or lawful permanent resident, and you say your husband was approved. If your husband was approved, you would have an approval letter. If he didn't get an interview, that's fine. Not every case requires an interview. So perhaps when you did the adjustment, he has no grounds of inadmissibility. Maybe you've been married for a long time. Maybe you have 3 kids. Maybe you clearly showed the bona fides. Maybe you had a good petition that went forward. So if it's approved, then it's a matter of moving forward. Now the question is, why wait 120 days for what? Are you waiting 120 days for the green card? Is that what you're waiting for? I mean, it's possible. It takes time to issue it, and I'd need to know if your husband is outside the U.S. or inside the U.S. If inside the U.S., if it's approved and it really is approved, not just you think it is, or not just what the officer said, that you have some document that's saying lawful permanent residency approved. Okay, if you have that, then and he's in the U.S., he can go to the USCIS, make an appointment, get an I-551 stamp on the passport, which shows he's a lawful permanent resident, even if he doesn't have the official green card, and that'll allow him to travel. If he's outside the U.S., then he has to wait for approval. Okay, he has to wait for the approval to come. I suspect that it's more likely he's inside the U.S. because it's less likely that they waived an interview if he's outside. Okay, that's also just a fact. U.S. citizen, parent in the USA, filed 485, then got denied, and now overstayed. Well, wait for the 485. Well, okay, so I can tell you that I bet I know what happened here. The U.S. citizen told the parent to come to the U.S. The parent got a visitor visa to visit, but came to the U.S. with the intention to really be petitioned for the green card. And within 90 days of entry, an adjustment was filed, and it was denied. And unfortunately, people do this because they think they're smarter than immigration. They don't know the law. They don't first realize that a B2 visitor visa, which I'm fairly certain that's what your parents got, is to come and visit. And you have to have what's called non-immigrant intent. That means that when you come to the U.S., that you intend to visit, go to Disneyland, see your family, and then leave. It does not mean immigrant intent, which is where you come with the intent to stay here permanently and get the green card. So the law says if you come here as a visitor and within 90 days you file, a petition contra to what the B2 is, as in an adjustment, B2 non-immigrant, visit, adjustment, immigrant, green card, it is presumed that you did not have non-immigrant intent and that you're committing fraud. It is presumed that your mom or dad came into the U.S. with the intent to get the green card, and they committed fraud by coming in and just filing the adjustment. Okay, now there's ways of arguing around that, and I don't know if that's the exact case, but I can pretty much guarantee that's probably what happened. And so at the present time, assuming that there's no realistic way to do a motion to reopen, like for example, if they really intended to visit and then came here and you as the U.S. citizen completely convinced them to stay, and you had them sell their property and you had them do everything when they were here, then it's possible to do a motion to reopen to overcome that presumption. Okay, but assuming that's not the case, which is likely not the case, then they need to leave the United States before they get subject to the 3-year bar, meaning that if they have not been here out of status more than 6 months, they need to leave. Then you need to do regular consulate processing, and now of course they probably have an inadmissibility issue because of possible fraud, so that makes the normal consulate processing much more difficult. That's why in cases like this, I say, look, don't try to play around with immigration. Don't pretend to come here as a visitor when you really want to just, be petitioned by your kids. Wait the necessary time, have them do regular consulate processing, And, it takes a year, year and a half, and then you come here, green card, no issues. Or at a minimum, when you come here, don't play around for at least 90 days. There's still an issue, okay? Still an issue, but at least after 90 days, it's a lot less of an issue. Okay, so there's ways of dealing with this, but you should probably contact my office so that their situation doesn't get even worse. Okay? Okay, so I think this was from a prior question. You say in detention center, and I know you sent me a question about removal proceedings. Again, that doesn't help because I need to know why they're in the detention. Did they serve a criminal crime? Did they serve in regular jail, regular prison, and then they were transferred to a detention center, and now they're going to be put in removal proceedings? You want to know if they can win? It's possible, okay? But I need to know what the crime was. I need to know what the sentence was. I need to know what your status with this person is. I need to know if they've been previously deported, if they have other grounds of inadmissibility. That, hence, is the purpose for a consultation, where I could let you know how I can help, costs, and so forth. Okay. Does a graduate student necessarily need to have a job experience in the U.S. or outside the U.S. to qualify? Well, that depends. There's lots of categories of employment-based visas. EB2, for example, requires that you have an advanced degree. Okay, or you have a bachelor's degree with 5 years advanced experience. So let's just say advanced degree. The EB3 requires you have a bachelor's degree or at least 2 years experience. So as you can see, with employment-based petitions, there are ways that you don't need to have work experience. However, you also have to understand that the whole purpose of the PERM, which is the first part of a normal work petition, which, if you're going to do the green card, 90% of the green cards are through EB2s and EB3s. Not the EB1s that I started off with, that the PERM, the bottom line of the PERM is it shows there's no available U.S. workers for the position. So if you're going to, let's say you have a graduate degree in computer science, yes, you can qualify for an EB2 petition if you have a graduate degree in computer science without having job experience. But qualifying and getting it granted are two different things. By just going out and applying for a PERM with just a graduate degree, even though you qualify, what you're basically saying, or what the petitioner is basically saying, is all one needs is a graduate degree in computer science to qualify for this job, and that's it. And if that were the case, just think about it. Any U.S. person here, or person legally here, who has a graduate degree like you do and applies, they're going to get it over you. The law says that the employer cannot reject them over you if that's all that's required. So, it takes some work to do a proper PERM. And even if you don't have a lot of experience, there's all kinds of other ways of showing other than just the graduate degree itself. So do remember that qualification and granting are two different things. Okay? All right, after the second, it just went down a bunch. Okay. Okay, well, and then this is the one I was talking about for you did file after 90 days. And as you can see, the issue did not just disappear, right? I mean, it was still denied, even though you filed after 90 days. So you played immigration is what happened. You obviously knew the law because you knew you should file it after 90 days. But that doesn't make the issues disappear, okay? I mean, your parents don't know immigration law, U.S. immigration law especially. They could have been at the interview, and the officer could have, been real nice with them. How you doing, whatever. And by the way, when you came in, what did you want? And your dad might have said, well, I wanted to live with my son, so, we came in and my son's going to petition me. Boom, denied right there. It shows the intent. It shows preconceived intent. It shows there was no non-immigrant intent, okay? So I'd of course, need to see the denial. But this is a clear example that you can't just look at one line in the law that says, if you file within 90 days of coming here in an inconsistent manner, you'll be presumed to have had non-immigrant intent. you can see there's lots of other issues because obviously it was denied, but there still might be ways to fix this, to make it happen. Okay, well, this isn't a question, but it says good morning. So good morning to you. I hope everything's going well. Okay, denied due to income issue. Well, that's easy. You just need to get a joint sponsor. Okay, so if you don't make enough, you need to find a U.S. citizen or lawful permanent resident that does make enough and have them do an affidavit of support, a joint affidavit of support. Okay, another hello. Hello, how are you doing? Okay, I think I answered all the questions today. If any of you have, want, I think someone said, hello, thank you. Oh, thanks for the heart. If anybody wants a consultation, just give me a call after, or, not a call, but call the office and they'll set you up with, what needs to be done. Thanks for the gift, by the way. Okay, just a minute. There was one question I didn't get to. Daughter petitioned for us. My husband got the green card without an interview. I interviewed 120 days ago. Oh, all right. So I see what you're saying. So you feel a little left out because your husband didn't have an interview and he has the green card. You've had to wait 120 days and you still don't have an answer. I understand that makes you feel a little unjustified here. What you have to do, there's no magic 120-day wait. You were interviewed and your petition has a right to be adjudicated because you can see right now you're in limbo, right? Every day you're in limbo. So you, after a certain period of time, if I were representing you, I would do a formal status, see what's going on. And then if they decided to just play around and say, well, is administrative processing, which to me says it's in a black hole and they're never going to look at it, then you have to prepare a writ of mandate, okay, which is a whole lawsuit against USCIS. Because when it comes down to it, unless you're inadmissible for some reason, maybe your husband wasn't, but maybe you are. Maybe you have some criminal history or fraud history or prior deportation history, or maybe, maybe you didn't show you're the biological mother of your daughter. I don't know. Maybe that's what they're looking at. But if really the issues are not different than that of your husband, then there's no reason that it should be delayed this long. So formal inquiry and a writ of mandamus if you have to, in order to go forward. Okay? Alrighty. Let's see. Okay, well, I think I've answered everybody. I think that does it for the live today. I hope everybody learned one or two things. Whenever I go to my continuing education stuff, even if I'm there all day, if I pick one good thing, I say it was a good day. All right? So everybody have a good day. Until the next live, I'll see you then.